afternoon and welcome to the latest in the webinar series, which we are delighted to welcome you to Hamid Courts, How Best to Avoid Them and Some Tips If You Can't. I am joined by Emma Harris, who you will hear from first. Emma is a recent recruit to our chambers. We are delighted to have her here, and I want to thank her for all her work on this and also more generally since her very recent arrival into chambers. I also want to thank Sarah Pinder and Samina Iqbal, who head the Immigration and Public Law team, and have done a wonderful job with this second series now of webinars. And I know that many of you will have been to various previous sessions, and I hope you found them informative and helpful, and will continue to do so. Can I remind everybody that there's the Q&A function in the side. So if you have questions, please ask them through the Q&A, and Emma and I will endeavour to answer them once we've completed our talk, our words. There's also the chat function, but that's probably easier to use just in terms of short observations as opposed to questions. So can I ask you please to do that? We will break the session up. We think it will be about 40 to 45 minutes. So that does allow time for questions. So please feel free to do that. And without further ado, I'm going to pass over to Emma, who's going to begin this webinar by just talking about the rationale and the brief background to the Hamid Court jurisdiction. Thank you.
Thanks very much, Tony. Starting with this then, the Administrative Court and more recently the Upper Tribunal have determined that the courts have an inherent jurisdiction to govern their own procedures, which includes ensuring that lawyers act properly and in accordance with their codes of conduct. The hearings adopted where a judge considers whether a lawyer may have acted improperly in the preparation and conduct of judicial review proceedings have come to be known as Hamid Courts after a relevant case, which we will discuss shortly. In this webinar, we're going to cover firstly how Hamid Courts came into being, and then Tony will take you through the circumstances in which Hamid Courts are likely to be convened against legal practitioners. I'll then go through the process which has been developed by the Administrative Court for dealing with these cases, and I'll advise on best practice in order to reduce the risk of becoming involved in a Hamid Court hearing, with a particular focus on urgent injunctions where this often arises. And then Tony will conclude matters with some tips on how we think it'd be best advisable to deal with the situation if, unfortunately, you do become involved in Hamid proceedings. So starting with the Hamid case from 2012 in the High Court, the Administrative Court set out its desire to employ its inherent jurisdiction to require a lawyer to attend court to explain their actions in cases where a judge concluded that they may have acted improperly. An application for judicial review challenging the lawfulness of removal and for an urgent injunction application had been made to the Administrative Court by a firm on behalf of a client who was due to be removed from the UK the following day. It happened that in October 2012, a new version of the form N463, which is the specific form that is used for urgent judicial review applications, that had only just been introduced in response to an increasing number of applications in respect of pending removals. And it was essentially to help the court to streamline that process. The revised form had a number of new requirements in it, including that the lawyer had to give reasons for the urgency, had to set out a timetable for the matter to be heard, had to give justification for the immediate consideration of the application, had to set out the date and time when it was first appreciated that an immediate application might be necessary, had to explain if there had been delay, why there had been delay, and also had to explain what efforts had been made to put the Secretary of State or any other interested party on notice. Well, in Hamid, the application that had been completed on the 24th of October 2012 didn't meet any of these requirements, and it went on to be further refused as totally without merit. The court identified that professional misconduct could arise if an application was made with a view to postponing the implementation of a decision where there were no proper grounds for doing so, and that was applying the case of Madden from 2007 in the Court of Appeal. In Hamid itself, the solicitor attended court, apologised and explained they'd simply not appreciated there'd been a change in the procedure. The court accepted the apology, but gave a very stark warning that non-compliance like this would not be allowed to continue. Failure by a firm to comply with the correct procedure in future would result in the requirement to attend court for the solicitor from the responsible firm together with their senior partner, and the firm was notified that they would be publicly named. The court also informed them that they would not hesitate to refer persistent failures to follow the procedural requirements to the SRA. So I'm just going to hand over to Tony for the next slide.
So the next question to ask is, when are Hamid Courts being convened? There are a wide range of circumstances in which Hamid Courts have been convened against both practitioners and firms. In the case of Awuku and others against the Secretary of State in 2012 in the Admin Court, and the second Awuku case, also 2012 in the Admin Court, and you've seen the citations there, they contain reference to 6 separate cases, of which there are quite a lot of variety. So the first one was the case of Hamid. Following the original Hamid case, a further application was made on virtually the same points, with no disclosure of the previous application and that refusal. And the court said that was a gross breach of duty of disclosure arising in an ex parte application. The solicitor was named, and although not referred to the SRA, was required to report to the SRA what steps were being taken to ensure that a proper training program was in hand within the firm. In the case of Muregza Pilar, there was an application to stay removal, and it was claimed that a suspensive appeal was pending when in fact the appeal had been lodged late and a decision had been made not to admit the appeal. The solicitor was in fact not referred to the SRA, but the case was marked as one where there had been a grave non-disclosure and a failure to comply with the rules of court. In N, one of the cases, in an ex parte application for a stay of removal, the solicitors failed to disclose that in the fresh claim being advanced, the Secretary of State's position was that the evidence being relied upon had already been considered by an immigration judge previously, and that the only additional document was inconsistent and unverifiable. Non-disclosure was accepted and an apology was made. The solicitor was not named or referred to the SRA though. In Awuku itself, that concerned a judicial review to stay removal. The issue there was that matters were raised in the judicial review, including the existence of a daughter in the United Kingdom and a political asylum claim that had not been mentioned in earlier proceedings, despite being known to the solicitors by their own admission. And no explanation was given as to why those matters were not raised at the appropriate time. The explanation given was that the appeal was not reviewed by a qualified lawyer, but this was not found to be a good cause. The firm in that case was named, but the apology was accepted and no further action was taken. And in the case of T&T, that concerned a challenge to a third country in relation to certification. A change to Home Office policy meant that the argument advanced was simply not arguable. Counsel and solicitors provided witness statements apologising profusely, and for that reason, they were not named, and in fact, no action was taken. In the case of the Crown B and another against the Secretary of State, it was held that the applications made were, in the court's words, nonsensical and were put forward by lawyers who simply did not have sufficient competence to practice in immigration law. Whilst counsel was heavily criticised for the drafting of the application, the solicitors also did not avoid criticism either, through their over-reliance on counsel, as they were reminded of their duty to instruct competent counsel and to satisfy themselves independently that the arguments could properly be made to the court. In the case of Butt and others, the Crown Butt and others and Secretary of State, the court had indicated that solicitors and firms might expect to be referred to the SRA after 2 or 3 referrals. In other words, they would have had an opportunity to make one mistake to the admin court to explain their conduct. That comfort, though, has now been thoroughly rejected, and the leading authority in that regard is the case of Sativel and others, Crown and Sativel and others against the Secretary of State in 2018. which we will cover in more detail shortly. But that's made it abundantly clear that the court will consider referring a case to the SRA on the very first occasion that a lawyer falls below acceptable standards. When looking at some of the those earlier cases following the lead case of Hamid, we should not be too reassured by any outcome where a referral to the SRA did not follow, because it is likely that such a referral would now be made in similar factual circumstances. In other words, as time has moved on and people were becoming more aware of the Hamid Courts and the jurisdiction, it's being more heavily scrutinized and earlier intervention is much more possible to contemplate. In the case of the Crown of Kondu and Abdul Salam and the Secretary of State in 2014, a referral was made to the SRA where a solicitor had signed statements of truth in judicial review proceedings, which were, in the court's description, grossly misleading and inaccurate, and who had sought to argue in his defense that the document had been prepared by a paralegal and that he had signed it without reading its contents. That solicitor was held to have acted recklessly and in a manner likely to mislead the tribunal. And on referral to the SRA, he was fined £10,000. In the case of Akram and the Secretary of State in 2015, that involved similar misconduct in the applications. The applications were made to the admin court, which were wholly without merit. And the principal solicitor who was signing the accompanying statement of truth had failed to scrutinize them. Of additional concern in that case was that the agreement between the solicitor and the client included an assurance that experienced counsel would be instructed, but in fact, no such counsel was ever instructed. The firm and the principal solicitor were named, and the matter in that case was referred to the SRA for investigation, although ultimately it appears no disciplinary action was taken. So some of the reported cases since Hamid have also included dishonesty and referrals to the SRA, which have led to serious consequences in those cases, including principal solicitors being struck off. In the case of Rees Sandbrook solicitors in 2015, the firm was found to have dishonestly engaged in a course of conduct by making applications which were totally without merit to prevent removals of its clients from the UK. So the motives, the laudable possible motives, were regarded by the admin court as irrelevant. In some instances where injunctions have been granted on an urgent basis without full disclosure to the court of the background to the cases, the firm that failed to pursue the proceedings, thereby preventing the removal of the client, but taking the matter no further. In that case, the firm was named, the matter was indeed referred to the SRA, and the principal solicitor was subsequently struck off. And there's a reference to that as Vaisui IP against the SRA in 2018 in the admin courts. More recent cases have shown that all different types of misconduct can indeed fall within the Hamid jurisdiction, and it is not limited, therefore, only to hopeless and/or last-minute judicial review litigation. In the case of Jetli, another Secretary of State in 2019 in the admin court, the judge was unable to proceed with a hearing originally in the court below. There was no signed statement of truth on the claim form. No bundle of authorities had been lodged. The trial bundle was described as completely inadequate. The solicitors were not on the record, and a letter from the firm purporting to be involved contained discrepancies which required resolution. At the next hearing, there was no evidence in that case that the claimants had directly authorized any firm whatsoever to act on their behalf. The solicitors whose name appeared on the record said they were never instructed to bring the proceedings, and a second firm had never formally come on the record. The whole matter was referred to the SRA and the DPP to investigate whether reserved legal activities had been carried out by a person or persons without the requisite authority. So it's a good example of the width of the Hamid type jurisdiction. Similarly, in the case of Hoxha against the Secretary of State in 2019, there was a referral to the OISC to consider whether a firm had been acting beyond its own OISC registration and 7 separate judicial review cases. The Hamid Court jurisdiction. Although the decision to hold Hamid Courts is taken by the High Court under its inherent jurisdiction, this is a jurisdiction which has also been claimed by the upper tribunal. That's the case of Shrestha against the Secretary of State in 2018. Additionally, it is important to note that the former president of the Queen's Bench Division announced in November 2018 that the Hamid jurisdiction is not limited to dealing with immigration matters and extends to all matters dealt with by the administrative court. Although we are not yet aware of examples of this power having been used outside of immigration, it is clear that everyone practicing in civil law more widely, and certainly public law, needs to be aware of the potential in relation to the Hamid jurisdiction, therefore. I now turn back to Emma, who will deal with the Hamid procedure.
Thanks, Tony. So the case of Sathivel, obviously in 2018, brought in really a clearer procedure that's now been adopted for dealing with these particular types of cases where lawyers fail to meet professional standards. It's been developed over time, and this case really summarises what's been built up. So when a judge concludes that a lawyer has acted improperly, that may be recorded in a court order, and the papers are then referred to the High Court judge having responsibility for this jurisdiction, and a show cause letter may then be sent. When a show cause letter is issued, the addressee must respond with a witness statement drafted by the person who is responsible for the case in question, and the statement of truth must be signed. It's important to note that to lie or deliberately mislead in such a statement might actually be considered to be a contempt of court. So a full, candid and frank response to all of the questions posed in the show cause letter must be included, and you must also deal with all of the issues set out in the court order referring the case. If there'd been a recent change of lawyers, as that does sometimes happen, the statement must include full particulars of the circumstances giving rise to that change. Relevant documents must be annexed, and a full account of efforts made by the solicitor to obtain all relevant documents from the old solicitor must be set out. If the court concluded that the change of instruction was a device, it would consider including in any complaint to the SRA the position of the previous solicitor. The court would not necessarily refer the matter to the divisional court before passing the file to the SRA as a complaint. So actually, they may even start bypassing these Hamid hearings altogether. A complaint can be made to the SRA directly on receipt of the response to the show cause letter if that's considered appropriate. And importantly, as Tony's already mentioned, the court will now consider referring a case to the SRA on the very first occasion that the lawyer falls below the relevant standards. So, as he said, some of those earlier cases are no longer really a comfort to us. And what this guidance really highlights is that the importance of that first response to the show cause letter. So when it comes to seeking to avoid having to deal with this in the first place, I mean, the main context for where these cases come from is often in situations where the removal of a client is imminent, an urgent injunction application is being made to delay removal, often after a fresh claim has been made quite late in the day. Counsel and solicitors have duties within their codes of conduct when deciding whether to act or to terminate instructions to ensure compliance with the law and with their codes of conduct. Some of the relevant principles applicable to solicitors include that they must act in a way that upholds the proper administration of justice, in a way that upholds public trust in the solicitor's profession, and they must act with independence. They must also not mislead or attempt to mislead the client, the court, or others, either by their own act or admissions, or by allowing or being complicit in the act or omissions of others, including their clients. And these same principles are echoed within the Bar Code of Conduct for counsel. So in circumstances where a client approaches a solicitor very shortly before removal, potentially from detention, it's going to be incredibly difficult to ensure that you're not misleading the court when you're dealing with the case. We consider that the following, and as set out on the screen there, to be essential reading for anyone doing this work. Don't worry about trying to take a note of these at the moment. We have got a handout that we're going to send out after this event. So you'll be able to have a full note of the talk and certainly have all of the references to the cases that have been referred to as well. But the main case of SB Afghanistan is very much essential reading. In that case, it didn't actually lead to a Hamid court, but nonetheless, it's must read for anyone handling urgent injunctions against removal, particularly in an immigration context. A person who can show that the guidance in SB has been followed will be in a much stronger position to avoid Hamid proceedings altogether, or to successfully defend themselves if that unfortunate event does happen. It's to be noted, the lawyers in SB were found to have acted honestly and in good faith, but they were held to have misrepresented the facts of the case to a judge by claiming that their client had the benefit of a suspension of a removal window when he did not. They hadn't had sight of all of the documents for themselves, and they made positive assertions about the factual content of those documents, which turned out to be incorrect. Now, the relevant paragraphs for you to consider are paragraphs 56 and 57 of that case, so definitely a must read. Paragraph 57 says, the duty of candour is directed in the most part to ensuring that matters unfavourable to the applicant are drawn to the attention of the judge. There is a strong imperative for those instructed late in the day to make no representations or factual assertions which do not have a proper foundation in the materials available to them. Gaps in your knowledge should not be filled by wishful thinking. And it notes that obviously in most of these cases where lawyers are coming into this case at the last minute, there will already have been a lot of interaction between the client and the immigration authorities, and often the appellate authorities as well. So there will have been a lot of documentation generated. And it says that it behoves lawyers to essentially make it clear and take a special care in the factual assertions that they make. It says there are times when advisors have clear instructions from a client which turn out to be wrong, and in the context of last-minute applications, great care should be taken before accepting them without inquiry. At the very least, it should have been explained that the account given in the grounds of claim put forward without documents, having in fact been checked, and reasons must be given to support the stated belief where there are no documents. And the reason for that is so that the judge can make a critical assessment of those reasons and would then also be put on alert to check the actual situation with the OSCU. Further criticism was also made that SB's representatives did not attempt to put the respondent on notice of the out-of-hours application through both formal and informal channels. So whilst they had actually used the official email address, they'd actually been in contact with the respondent earlier in the proceedings and had an informal route that they could have used, and they didn't actually use that to notify the respondent. So it was reiterated then at paragraph 56 of the decision as well that steps to challenge removal should be taken as early as possible and should be taken promptly after receipt of notice of a removal window. And also that applications to the court for interim relief should be made with as much notice to the Secretary of State as is practicably feasible. Guidance was also directed towards judges hearing such cases, as it was suggested they should check with the Secretary of State's Operational Support and Certification Unit, that's the OSCU I mentioned, because that will be able to give them the immigration position of the applicant at very least. So a few takeaway tips on this then. Before taking on a case at the last minute, think carefully about whether you can properly represent your client's interests and do so in a manner that does not place you in breach of your other duties to the court and to the administration of justice. If an application is going to be made, make sure it's made as soon as possible. Ensure that the correct form is used and fully completed. And be extremely aware of the duty of candour in such cases. And what that means is highlighting the gaps in your knowledge and in the documentation, ensuring that if you are making factual assertions, they are positively verifiable from the documentation available. If the documentation isn't available and you've been unable to verify an assertion, then that fact needs to be made very clear, and the reasons must be given why you've nonetheless stated that belief, i.e. because it was from your client's instructions, for instance. If information comes to light, which means that it becomes clear that something said in an urgent application was false or misleading, then that must be brought to the attention of the court immediately. Where there's been communication with the Secretary of State in previous decisions, i.e. in an ex parte application, the Secretary of State's stated position on the case must be disclosed to the court if it's known. And all of the points that militate against a grant of relief must be put on the face of submissions and addressed. Must also put the other side on notice of an application being made at the earliest opportunity and by all practical means, not only by the official channels if you have already made contact with the respondent by other means in the case. I'm just going to hand back to Tony to wrap up.
Thank you, Emma. So I guess I better talk about the case in which I appeared as leading counsel on behalf of a solicitor, Mr. Ahmed, in the case of Singh and others against the Secretary of State. I appeared together with Dr. Anton van Dellen, who was a former member of Chambers, is now still a door tenant, who brought me into the case. He was very aware of the background to this case and brought me in because this was, we saw as a potentially quite a serious case. It was a Hamid hearing that took place on the 20th of January of last year. The matter concerned the solicitor's conduct in respect of 7 separate judicial review claims lodged by the firm, which had been certified, all 7 had been certified as totally without merit, and in particular focused on the duty of a solicitor to take ownership and responsibility for such claims. A number of notices to show cause were issued to the firm, 12 bridge solicitors, between September 2018 and July 2019, as a consequence of claims for judicial review being issued by that firm, which were all certified as being totally without merit. Mr. Ahmed, who was the director at 12 bridge solicitors, had been spread thinly between his different places of work, as he was practicing, in fact, from 2 different branch offices as a solicitor, and was, in addition to doing that, operating from 2 sets of chambers as a self-employed barrister. So you can see he was really all over the place in terms, literally all over the place in terms of what he had to do. Approximately 40% of his time was spent at 12 bridge solicitors' offices, and in immigration matters, he had the assistance of another solicitor, but essentially, apart from that, was otherwise responsible for the supervision of 2 caseworkers. The failings in relation to that case and the firm and his failings identified included a failure to include relevant documents within the application, the inclusion of irrelevant and misleading post-decision material, the advancing of legal argument which was totally without merit, a failure by the qualified staff to properly supervise those without legal training who were operating well beyond their knowledge and understanding when drafting grounds for judicial review and grounds to the Court of Appeal. Thankfully, despite this litany of errors, the panel were persuaded to show leniency and did not refer the solicitor to the SRA. The reasons given included the fact that the solicitor had exhibited contrition and acceptance of all the errors made. And secondly, he gave oral evidence before the court of staff training and a more robust structure for supervision in the future. So we can see, I think, responding from the authorities, what we can detect from those authorities, the experience and the procedures identified, that unfortunately, if you do reach the point where a show cause notice has been issued, it must clearly be dealt with promptly and robustly. And we're giving you a few observations which may assist in relation to the best way to deal with the situation in responding to the show cause notice, partly based on my experience on the case that I've taken you to. First, a comprehensive and detailed witness statement or statements should be drafted in response to a show cause notice. Secondly, address all the alleged failings. If there have been some or all which have been accepted, ensure the statement contains a clear and unequivocal apology. Thirdly, the statement should explain why any failing has occurred historically, but where the fact of the failing is not disputed, it is far better, we think, to hold up your hands to the failure than to seek to justify it. Justifications, as you'll appreciate, I'm sure, can have the opposite effect to the one intended, as they appear to be minimizing the impact upon the court. Fourthly, devote the majority of the statement or statements to showing precisely what changes have been made to the systems and the processes and what training has been undertaken to ensure that such failings will not be repeated. In other words, to show if not a one-off, it's a historical problem that's going to go away in the future. Fifthly, if it is an issue of supervision, as it was true in the case of Singh, then evidence can and should be produced of a change in staffing, new systems for supervision, and the use of outsourcing where appropriate. And finally, when it comes to getting training for staff, we think it can be useful to be able to show that a program of regular training has been put in place, rather than just as a one-off. And also, importantly, that a reputable external training source has been used to ensure that the training was of high quality. So we hope this has given you something of the background in relation to the Hamid case, the jurisdiction, the procedure, and how best to avoid coming before Hamid Courts, and if you are, the best way to deal with that situation. We know already, which has been put on the Q&A, and I will just mention that we hadn't located a case in a different jurisdiction, but you'll see from the Q&A chat that Alan Robertshaw, we're very grateful to Alan, has provided a case which I don't think it ultimately ended up as a Hamid case, but Hamid jurisdiction was threatened. And although there wasn't a full Hamid case, as the SRA already involved, we can see effectively it was very similar to a Hamid hearing, and he's helpfully provided the link to that case. So it adds to our point that this jurisdiction is not going to be limited in the future to cases of immigration law. So can I thank you on behalf of Emma and I for listening, and we are available for any further questions that arise. Emma, anything so far?
Nothing so far in the Q&A or in the chat, but of course if you do have any questions, you can. I think there is also an email address that you'll have had at events at goldsmithchambers.com, and certainly you'll be able to ask any follow-up questions later if you think of something after the event. But actually we do have one just here. It says, in the Singh case, did you say the solicitor practiced as both a barrister and a solicitor? Yes, he did.
He did, and that was part of the problem, that he just was literally spread too thinly in terms of his commitment. I don't think anybody, there was no challenge essentially to his honesty, but the fact that he just simply did not have the time and attention to ensure the processes were in place to ensure that problems would not arise.
Yeah. It certainly seemed to be similar to some of the other cases that we'd talked about as well, one where people, there just was a lack of supervision. People, paralegals and caseworkers were signing off, well, or getting their supervisors to sign off documents which hadn't been properly read through. So we've got another case, another question now, Tony, if you want to deal with this one. How were Hamid Court hearings different from professional misconduct hearings?
Well, they're not a professional misconduct hearing, because the situation in relation to Hamid Courts is that you are before a court. The Hamid Court tend to be before the upper tribunal. So you are before a court in relation to, so it's a step before a referral to the SRA, in which essentially the allegations in relation to the failed JR applications deemed to be totally without merit are considered by the court. In other words, it is open to the court, and they will hear evidence from this, and clearly we've said how that can be done, both in terms of witness statements and potentially oral evidence as well, that the Hamid Court hearing, the tribunal will determine whether, on the evidence presented, particularly in relation to the points that we sought to suggest to you to minimise the risks, as to whether a referral to the SRA follows. Of course, it's an independent jurisdiction. The SRA can be involved, and Alan's mentioned a case where there was a referral to the SRA before the Hamid type jurisdiction was put into place. So it's a separate jurisdiction, but it is open to the tribunal to subsequently refer to the SRA depending on what they hear.
Thank you. Is there a risk that Hamid Courts encroach into statutory appeals within the field of immigration?
Emma, do you want to deal with that one?
I certainly can. I think it's probably something that the statutory appeal courts would like to. Certainly now that the upper tribunal has, or at least has asserted that it has the inherent jurisdiction to deal with it in judicial review matters, I think there is perhaps a risk of it slipping into appeals as well. If it considers that it has the jurisdiction to do so, I'm sure they would want to.
the question about the full citation of the Singh case, as we said to you, we will be providing our speaking notes available after this webinar, and it has been reported, and we will ensure that we will footnote the full citation for the Singh case.
And then I think the final question we have at the moment is, what if as a representative you had not been provided with the information which later becomes apparent in proceedings? Can you disclose it without any trouble later? Perhaps I'll field that one. It's I think the point is, certainly as soon as new information comes to light, you need to disclose it to the court as soon as possible. That's obviously your duty, otherwise you're going on misleading the court inadvertently at that point beforehand. But after this point, once you know that it's incorrect, you need to correct the error. In terms of whether there'll be any trouble from it, I think the point is, from the case of SB and the guidance that we have, is there shouldn't be any trouble as long as, when you first made the application and those grounds were drafted, it was made clear what you did and didn't know. If this is a document that you never knew even existed that's suddenly come to light, then I don't think you can be criticised. But if it's a document that you just didn't have sight of at the time, but you've made some positive assertions about what you say is in that document, and you find out that's wrong later, you need in the grounds to have identified that you didn't have sight of the document. And so that's part of the drafting of the grounds in these sorts of cases. Thank you, Emma.
I think that probably, do we think we've got, yes, I think we've got all the Q&A questions. We've had some nice comments in the chat. Thank you very much indeed for those that have done. We do have another question. Just having a look at that question. If during the case you are called upon by the court to give written reasons to explain the reason for delay and why the case is not ready, can you drop the client in if the delay is entirely the fault of the client, even where it may damage his case? It's a very interesting ethical question. I'll try and deal with that. I don't think that's specifically a Hamid jurisdiction type case. It's a real balancing exercise. I mean, you've got to act in the best interest of your client. And I think the general rule about that is that where you can protect your client without misleading the court, you should do that. But if there's a question that you as a professional advocate who's going to be criticized, it's going to be you or the client who's going to be criticized, you have a very fine, delicate decision to make. And if you are asked directly from the court as to how this delay arose, I think you are entitled to say that this has come recently. But I think that should be a last step, because you really want to represent the client to the best possible interest, and anything like that is going to no doubt reflect badly on the client and therefore reflect on the merits of the case. So as a last resort, you will need to be open with the court if pushed. But it should be a last resort to disclose voluntarily, essentially, that the client has put you in this position. But certainly, if you are pushed, then I guess you would have to.
I will say just on that, in relation to urgent injunctions, it's on the form. The question is on the form. If there's been delay, why is there delay? So you are being asked directly at that point. And obviously, it'll be a bit more difficult, I think, to dodge that question when you have to answer it directly.
Yeah. I'm sure that's right, and unfortunately that is something that may disadvantage the client, but the reality is that is something that the court will be looking at, will be interested to know. Thank you. Anything else, Emma? Do we think we've got any more questions?
I don't think there are any more questions in the Q&A. I think I'm just checking the chat as well, just to make sure. No, I think that's everything. I think that might be us done.
Well, can I thank everybody again for attending and your very nice comments. We've really enjoyed doing it. As Emma rightly said, we will ensure that the speaking notes are made available publicly. So we'd be very happy for you to see those in due course, and we will update them specifically to deal with the one question which has the citation to the Singh case in which I was involved. So we wish you all a very good rest of your day, and thank you very much again for attending.
Thank you.